Alex here with part 114 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We move now into the petition for writ of mandamus filed in the lower court as promised. It didn't take me long. I read the Supreme Court's opinion, and within days, I prepared a petition for writ of mandamus, and I filed it in the district court as they instructed me to do so that the district court could conduct the fact-finding required under the new procedure that they outlined in Falcone v. Secretary of State. The petition, for the most part, was, I think, a clone of the one that I filed in the Supreme Court. The major differences would have probably been citations to Falcone v. Secretary of State and the procedure that I was going to have the district court comply with. This case is filed with a different judge, and in fact we could probably talk about that when it comes up in the My Docket series, because it's going to get filed with a non-family division judge, and then when he reviews the petition he actually transfers it back to the same family judge. And the reason that he does that is the one family, one judge rule, and there's also another sort of, I guess, technical reason as to why he does it, and that's the Landreth case in Nevada. Again, we'll talk about that stuff when we actually get to it in the My Docket series. It is going to come up. I cannot remember anything negative about my mindset at all. I was very excited. I was very positive. I knew that the decision was all of the wind in my sails that I had ever needed, and I also knew that this is not a decision that the court would be able to dodge, because the publication itself stated clearly that review of my ex's enrollment in the confidential address program was mandatory. So I definitely was enthusiastic, I was gung-ho, I was ready to go, and I suppose with that being said, we can actually just go ahead and take a look at what I have filed. We're going to start this one off a little differently. This is not the main document. This is the application to proceed in forma pauperis, which would have been the first document filed in this new lawsuit. Yes, this is a new lawsuit. As the Supreme Court indicated, they could not conduct the fact-finding, which meant that I had to file the case in the lower court, which I did, and it's going to have a new case number, and unlike the other case, this is not in the family division. This is going to be a non-family division case, even though later on the family judge just ended up taking the case over. It still is not considered a family division case. It is in fact considered a special proceeding in the lower courts. So again guys, we're going to get to the main document later on. The reason I didn't want to follow my normal pattern, which is the main document first, is because I thought it might be confusing for people to see me go through the application to proceed in forma pauperis later on. This is not a document that gets filed later on. This is a document that gets filed with the petition, and the reason is you need approval from a judge to even file it in the first place. And the reason why is I am trying to file this document for free. I am trying to avoid paying any of the filing fees. You already know I don't have an attorney, so I'm not paying attorney fees, but at this point in time I was so poor, I was in college, I wasn't making much money, and so I wanted to not only avoid paying attorney fees, I didn't even want to pay the costs to file it. And that is what I am doing here by filing my application to proceed in forma pauperis. Forma pauperis is Latin for in the form of a pauper, and this is one of the ways that you can get access to the courts when the filing fee isn't really so much sort of your ticket to get consideration, but rather it's more of a barrier to court access, because The Supreme Court, at least in Nevada, does understand that it costs money to litigate these cases. It costs money to process them, and that people should pay a filing fee to sort of fund the court system. But at the same time, the Supreme Court recognized that this filing fee can actually become a barrier to the courts for people who are in extreme poverty. Anyway, I'm going to go ahead and go into this now. Standard introductory paragraph. I am introducing myself to the court as the plaintiff. I have identified myself by name, and I have indicated that I'm filing the application to proceed in forma pauperis. I should have mentioned that I was appearing in proper person, but for whatever reason I didn't do that. That's one of the ways that you could indicate to the court that you do not have an attorney and you are representing yourself. We go into the points and authorities and straight into an affidavit. I am stating here, under penalty of perjury, that I need permission to proceed without having to pay any fees, costs, or security because I am unable to pay those costs. The first assertion here is that I filed the original writ proceeding in the Supreme Court of Nevada. They reviewed that case and they found constitutional inconsistencies and published a new decision they published an opinion in that case expanding Nevada case law. The next assertion that I'm making is that I was expressly authorized and instructed to file this writ petition in this court. The next assertion is that I did pay a filing fee in the Supreme Court, and more often than not, I can pay the filing fee, but when I was unable to, I've used forma pauperis status responsibly and to successful effect. I've indicated that I pledge to, on prevailing in this matter, file a motion to compel the losing party to pay the court costs. And this is the law, guys. When you get a fee waiver and you win your case, the court is supposed to order the losing party to pay the fees and costs that you would have paid had you paid them. Next assertion is that I am presently employed, at least at this time, as a paralegal, earning $15.50 per month. Next assertion is my checking and savings account and their combined balances. Next assertion is that I don't own real estate, stocks, bonds, etc. I own a vehicle. Next assertion is that I have student loan debt. Next assertion is that I have medical debt. Next assertion is that I have a child of age 6 who's dependent upon me. Next assertion is that I have monthly expenses, including food, transportation, childcare, rent, utilities, etc. Next assertion is leftover income, which is needed to cover educational expenses for myself and my child. And then we go into the signature. I cite the law. Here is the statute 12.015, which allows you to proceed in forma pauperis if you cannot afford to pay the filing fee. This is a constitutional issue, guys, so even if the state legislature did not enact this statute, the Constitution would open the doorway for you to do this anyway, and that's because of two constitutional principles. One is the right to petition redress, and the other is the Equal Protection Clause. And these two constitutional rights, the petition redress right and the equal protection right, is what combine to create this vehicle to get access to the courts, and that is the forma pauperis vehicle, which is free access. And we go into the conclusion, which is basically containing some Supreme Court rules and precedent supporting everything that I just told you about getting meaningful access to the courts as a poor person. Then we go into the list of exhibits. We have 1, 2, 3, 4, 5, 6 exhibits. These all look like new documents, so I will go ahead and go through all of them. Exhibit 5 looks to be something that was entered in the child custody action, and so that one I'll skip over. My policy, guys, is to not go over duplicate documents. If I've already gone over something in my docket series and it comes up again, I will skip over it. But remember, just like all my other videos, down in the description below are a bunch of links. You can click on those links. You can download these documents for yourself. You can review them, and if you find something in them that you think I should discuss, just mention it down in the comments below, and I'll go ahead and do that. Exhibit 1, and it's a paycheck. I'm not going to really go through my paycheck. Anyone here who's had a job knows what a paycheck looked like. If you guys want to, you can go ahead and look at the paychecks yourselves. Again, you can ask questions if you want to. This is, I think, what is this? 7 years old paycheck, so I don't really care if you guys have my information. Another paycheck. Another paycheck. Exhibit 2. Bank account. Same thing. I'm sure most people here have bank accounts. They know what these look like. I'm not interested in hiding this information from anyone. It's old information. I don't even have these accounts anymore. I'm going to go ahead and go to the next one, Exhibit 3. We have insurance, probably a bill. Anyone here who's got a car has seen an insurance whatever it's called, a bill or payment or whatever. Same thing, guys. You can go ahead and mention something down in the comments below if you have questions, but I'm going to move on. Student loan. Most people here have student loans, I'm sure. Exhibit 5. This is the court order we already went through in the child custody action. It's old. I'm going to go ahead and skip on through. Exhibit 6. What is this? Looks like maybe a credit card or something. Most people here have seen a credit card bill. Same thing, guys. You can always look down in the description below. Download this for yourself. Take a look. I don't really mind. Request for submission. If anyone hasn't seen the video yet, please watch my video, Request for Submission, to understand more about what this does. It basically turns a little light bulb on in front of the judge. I mean, not literally, but it gets the court's attention, lets the court know that there is something that is ready for the court to consider and render a decision on. Here we have the order granting motion to proceed in forma pauperis. The judge summarizes that he's reviewed my motion to proceed in forma pauperis. He cites the law that I cited. He states clearly that I have provided sufficient financial information to warrant granting the motion, and he orders as followed. Number 1, I am granted forma pauperis status. Number 2, it is allowed for me to proceed in this action without payment of costs, and that I can file any necessary writ, process, pleading, or paper without being charged. And he also orders the sheriff to serve anyone that I ask to be served without charging me. Certificate of mailing. His court clerk indicates that this order has been mailed to me, consistent with Rule 5. Next document. Petition for writ of mandamus. So here we are at the main document. Again, guys, usually I will go into the main document first with these videos, but I thought it would be especially awkward because I think it's important for you guys to see that first I got authorization and permission to proceed in forma pauperis before I actually went into the actual petition for writ of mandamus itself, which I'm about to go into now. Also, take a look here and you will see that there's a file stamp indicating when the document was filed in the upper right-hand corner, but you will also see that there is a received stamp down here in the lower section of the document. This is used to assist any review on timelines. Say, for example, that somebody tried to say that I filed something late. I would be able to say, well, it wasn't my fault. I tried to file it on the 3rd, but because of certain procedural issues, it wasn't filed until the 15th. It's not my fault. I got it to the court on time. The court received it, but the court didn't file it for whatever reason. And that's why you want to make sure that any document that you take to court that is not filed is stamped received, because sometimes these technicalities will come up and attorneys will try and lie and say, no, he didn't try and he's just late. He's just trying to get by on filing something late. And you'll need this stamped so that you can say, hey, no, I'm not late. I tried. The clerk just didn't put it into the system. Definitely take a look at the video. I think it's titled Clerk Refusing to File, because I actually talk about the importance of getting the received stamp on your documentation when a court rejects your filing. In this case, it wasn't rejected. They just held on to it until they can get approval from a judge. The petition for writ of mandamus. Initial paragraph identifies myself as the petitioner, indicates to the court that I am representing myself by stating I'm appearing in proper person, and identifies the document being filed as a petition for writ of mandamus. Here we go. It looks like a long document, but it's probably going to be the exhibits that make it long. At least I hope so. Also, guys, I suspect that there are going to be parts of this document that are copy-pastes from the previous petition that I filed in the Supreme Court. When I get to those portions that are copy-paste, I'm going to skip over them. If you've been watching the My Docket series in order, you will have gone through those portions of the document anyway, so you don't need to see it again for a second time. Indicating right here in the first section that, and I want to get the court's attention on this right now, the Supreme Court told me to do this. I really want to take the judge's face and put it right here. Read this immediately. I want it to be clear to the judge. This is something that I am doing because the Supreme Court said so. The Supreme Court is your boss. They are the ones that control what you can and can't do along with the legislature. But in any event, I really wanted to put this at the top of the document to make sure that the judge wouldn't miss this and assume that I was just some random non-attorney trying to annoy him with legal jargon that he didn't understand. I wanted him to know that the Supreme Court understood. The Supreme Court published a case. The Supreme Court wants you to follow these rules. And the first thing that I want you to see is the fact that the Supreme Court said so. So again, guys, the first section here discusses my filing in the Supreme Court and their publication and their procedure as established. I'm going to go into the related cases here. I'm not going to need to talk much about these guys. If you've been watching the My Docket series, you will know all about all 5 of these cases. Factual background. So most of this factual background I am going to skip over, guys, because this is copy-paste. Looks like right here, this is the only thing that's new, is the final paragraph in the factual background, which states that on April 25th, 2013, a panel of justices of the Supreme Court of Nevada entered a published opinion in this matter, which will control this case going forward. Legal analysis. Because the Supreme Court of Nevada has tied many of the procedural loose ends on this matter, and for the sake of brevity, I've constrained my factual background and upcoming legal analysis to the questions of law and law directly related to the newly established Falcone analysis. So I'm not going into all the other stuff. I'm only going to talk about Falcone v. Secretary of State, and I'm really emphasizing as much as I can. I'm underlining it, I'm bolding it, I'm circling it in red ink, that Falcone v. Secretary of State will control this court. Okay, so mandamus is the only remedy available to me. I am stating that under Falcone v. Secretary of State, the Supreme Court of Nevada has stated clearly, Falcone presents important legal issues regarding the fictitious address statutes and a co-parent's ability to seek disclosure of that parent's address that needs clarification, and he does not have an adequate remedy at law. Normally, you have to prove to the court that you don't have an adequate remedy at law. In this particular case, I'm telling this judge, these aren't even my own words. This is the Supreme Court of Nevada telling you that I don't have an adequate remedy. Not only do I not have an adequate remedy, but they also state that consideration of the writ petition is appropriate. These are their words. The next assertion here is that the Supreme Court of Nevada expressly discussed the applicability of mandamus in the instant case. Again, I am not using abstract legal principles to come to this conclusion. They have stated this plainly. From the Supreme Court's own mouth, we conclude that as a co-parent, Falcone may seek disclosure of Farrar's address in the district court by extraordinary writ, and in determining whether to grant the writ, the district court must, and I love that word, guys, because if it's not there, the judge won't do it. Unless you have an attorney. When you're a non-attorney, they try and do everything in their power to just get rid of you. I explain why in the video Self-Representation Bias. Please watch that video for a detailed explanation as to why. In this particular case, I've got wind in my sails. The Supreme Court of Nevada says that the district court must consider whether or not my ex can establish that I was actually a perpetrator of DV. The next assertion here is that the Supreme Court of Nevada is stating plainly and expressly that the procedure requires the secretary to be made a party to the writ petition and that the program participant be made a real party in interest. Again, they use that word must. They use it twice. In this way, a petition for writ of mandamus allows me to give proper notice and bring all interested parties into the proceeding, which is what I did in this case. Next, we go into the respondent's role in the proceeding, which is merely observational. And this is true. The Secretary of State, for the most part, isn't going to be turning the wheels of justice in this case. Pretty much all of the burden is placed upon my ex. The Secretary of State is only included because they are going to be told what to do by the judge in the end, and they have to be a party. The court has very limited power in telling a non-party to do a certain thing. There are certain ways that this can be done, but it still involves them being roped into the case in some manner or form. In this particular situation, the Supreme Court of Nevada wants them named in the caption. So in discussing the propriety of the Secretary's issuance of a fictitious address to my ex, the Supreme Court of Nevada stated that, quote, the fictitious address program does not authorize the Secretary of State to investigate or determine whether a protective order was issued based on a finding of DV or on a finding of potential threats. Furthermore, early versions of the bill required the Secretary to make a determination, but for whatever reason, the bill was modified to remove that discretionary power from the Secretary of State. Next assertion is that under the Falcone analysis, it is entirely my ex's duty and not the government's to defend her right to remain concealed. In light of this conclusion, I am releasing the Secretary of any claims of wrongdoing, and I am waiving my right to seek an award of costs or attorney fees against the Secretary of State. Even if I didn't do this, I wouldn't be able to get any of these anyway, because as the Supreme Court of Nevada mentioned, they don't really have any ability to exercise any sort of discretion anyway. It's not really their fault. The legislature forced them to do what they did. So if anyone's at fault, it's my ex and the legislature. It's not the ex and the Secretary of State. Next assertion here is that the Supreme Court of Nevada discussed, while we conclude that the Secretary of State was required to accept my ex into the program, my arguments, especially my focus on the fictitious address's interference with my ability to parent and the facts of the case, highlight potential problems that may arise when a parent who shares joint custody of his or her child is admitted into the program. Supreme Court of Nevada, by the way, guys, I say Superior Court with a little s, a lowercase s. Some people have asked me before, why do you do that? There's no Superior Courts in Nevada. Those are in California. Yeah, those are capital S Superior Courts. It's actually the title of the type of court in California. You can use it in lowercase format when you're just saying, hey, it's the court above the current court. I'm saying that this court is the boss of the district court. That's what I'm trying to say with the lowercase superior. Anyway, our Superior Court went on to elaborate that the fictitious address statutes cannot be permitted to run roughshod over all other applicable legal doctrines and issues, and that the district courts must consider the balance between these two issues. I'm citing the case again, stating that when a parent shares joint custody of his or her child and they enter into the fictitious address program, the custodial parenting issues become intertwined with the DV victim's need for protection. Thus, in such a case, the rights of a custodial parent to know where his or her child resides must be balanced against the important state interest in protecting victims of DV served by the state's fictitious address program. In grasping for a solution within the existing statutory scheme, the Supreme Court of Nevada found authority for the district courts under the law. And they used this law to empower the district court to do what it's supposed to do, which is to turn over my ex's confidential address. While the statute gives the district courts the authority to order a confidential address released, it is entirely silent as to its application. In practice, 2 district judges have already shied away from exercising their discretion in an area of law that at one time appeared all but entirely in the hands of the secretary. And I'm calling out District Judges Stephen Kasach and Chuck Weller. Our Supreme Court wisely selected persuasive authority from New Jersey that both releases the district courts from what appears to be the overriding force of the government's fictitious address program and confers upon those judges the authority to make independent findings of fact, and in weighing both the right to keep one's address secret against the right to know where one resides, render a legal determination on whether that person's address should be revealed or remain secret. And this is the portion of the case law that explains this. The Supreme Court of Nevada punctuates their discussion with an express adoption of the New Jersey decision, and they adopt that framework into Nevada law. Now I am going into my argument. I am entitled to know where my ex resides because the Supreme Court said so. And I go into all of the statements made by the Supreme Court. And then I go into the United States Supreme Court decision that actually ties in the constitutional rights that parents have in raising their children. We have a child that lives with, sleeps at, eats with, and learns from 2 parents. Both myself and my ex have substantial amounts of time with our son, 40%, 50%, something like that. Judicial estoppel precludes my ex from taking any position contrary to this, and I'm basically using judicial estoppel against my ex's lawyer. My ex has made numerous statements in the lower court that both parents were entitled to know where our child resides. She argued numerous times that my ex had a right to know where I resided. And so what I'm doing is I'm using the estoppel of inconsistent positions against my ex's attorney to basically straitjacket her into that position. I'm basically saying, since you said that your client is entitled to know where I live, I am entitled to know where she lives. And that is one of the wonderful things about judicial estoppel. If you guys want to learn more about judicial estoppel, take a look at my video, Judicial Estoppel. I don't really need it in this case, but I really wanted to reinforce the fact that my ex's attorney has made this position in the past. And since she has made this position against me, she now has to eat her own words and be bound by that same statement that she made. Next assertion here is that my ex's reliance on pure speculation, bare allegations, and conjecture must fail. And that is because the Supreme Court said so. She has to prove it now. She has to prove it by clear and convincing evidence as well. If you want to learn more about clear and convincing evidence, please take a look at the video, Clear and Convincing Evidence. I'm citing all the laws here, guys, that I cited in the previous Supreme Court case. I'm going to skip over it. Okay, so I'm at this point pointing out the fact that the court should give little credence to my ex's restraining order because the Supreme Court of Nevada, and I quote, Nothing in the record establishes the specific grounds upon which my ex's restraining order was sought or the basis for the grant of the order, unquote. Those are the words of Justice Michael Cherry of the Supreme Court. He's the one saying that my ex did not obtain the fictitious address until after the custody order was entered, unquote. Moving on to the next assertion, my ex has to show by, quote, clear and convincing evidence that I have perpetrated DV against her. Now is the time for her to show this. Here is the opportunity. Again, I've mentioned this before. Spoiler alert, she doesn't even go to court because she knows she can't prove it because it never happened. Next assertion here is that her restraining order serves as prima facie indications that necessarily require her to demonstrate to the court the actual facts and the actual circumstances. In the instant case, just like in the New Jersey case, my ex is exploiting procedural tactics to conceal the underlying conduct and go into all of these decisions in the lower court. Just like Mrs. Sakharov, my ex's enrollment in the confidential address program was nothing more than, quote, outgrowth of a matrimonial matter, unquote. And it has only served to undermine my parental rights and the safety of our child. There is no practical purpose for it, and it has served to poison the dealings of the parties since its inception. My ex has used it to alienate the child, school personnel, medical personnel, friends, family, and even the Discovery Commissioner against me. The only difference between these two cases is that the trial court in Sakharov erred in refusing to engage in fact-finding before denying Ms. Sakharov's request for secrecy on the grounds that she failed to obtain a restraining order, whereas the trial court, in my case, erred in refusing to engage in the fact-finding before denying my request for my ex's address on the grounds that she succeeded in obtaining the restraining order. In conducting its analysis of this phase, the court should also make specific findings of fact that support the determination that one or more acts of DV have occurred. Such a request is consistent with the law and would assist our superior court on appeal. So I'm making it clear right now. No funny business from this court because I will file another appeal. And guys, I do file several more appeals. And the decisions of these judges is overturned not once, not twice, not 3 times, but 4 times because they do consistently push their boundaries and violate the law in this case. Luckily, this is not a situation where they're going to violate the law, but there will be a number of violations of law from 3 different judges that I go through, and you guys are going to go through all of those violations of law as we go through the My Docket series. Concealment of my ex's address is not in our son's best interests, and I point this out with some of the old discussions in the Supreme Court, so I'm going to go ahead and skip through this. I've already gone over this stuff, guys. All of this stuff I've already gone over. All of these. If you've gone through the My Docket series in order, you'll have seen these. Procedure under mandamus. Mandamus proceedings are governed under the rules of civil procedure and the law. Though the court can order a jury trial pursuant to the law, I would request a bench trial as a more reasonable alternative. Absent a finding of an answer by the government or my ex that introduces new evidence, there does not appear to be any genuine issues of material fact that exist that would warrant a hearing on this matter. So I'm actually just asking the court to render a decision on the pleadings. Mediation is futile, and again, guys, this is boilerplate that I've started to include in all of my subsequent filings with the courts because going to mediation with my ex is a complete and total waste of time. If you want to know more about this exception, please watch my video, Mediation and Settlement. The exception that I'm talking about is WDFCR 53, subsection 14B3. And in that subsection, I have support for getting out of going to mediation with my ex. Discovery. I am requesting that the court order my ex to provide all documentation on her mental health, including but not limited to papers, files, and things regarding her stay at the Mental Health Institute for her attempted suicide. As an alternative, I am requesting that the court open formal discovery consistent with Rule 26, subsection A. This doesn't end up happening because she doesn't file anything. Conclusion. I am basically running through what I've already stated before, which is that the Nevada Supreme Court has seen fit to rectify this miscarriage of justice by not only authorizing our district judges to engage in fact-finding and render decisions on our existing fictitious address program, but obligating them to do so. And then I go into the conclusion, which is a request that the court issue a writ of mandamus commanding the Secretary of State to revoke my ex's fictitious address, and that the court issue a writ of mandamus compelling the Secretary of State to turn over my ex's fictitious address, my ex's true and actual address on file. I also want an award of costs. I also want an award of attorney fees. And just so you guys know, I get all of the things that I'm asking for here. The court will order the government to both cancel my ex's fictitious address and turn over her true and actual address. Verification, which is, as mentioned in previous videos, the swearing under oath by me, the petitioner, that all of the facts alleged in this document are true and correct. List of exhibits. We have 1, 2, 3, 4, 5, 6, 7, 8 exhibits. I can already tell that some of these I've gone over in the My Docket series. Exhibits 1, 2, 3, 4, actually 5 and 6 also, and 7. No, all of them. So guys, I've gone over all of these exhibits. So I'm not going to do this again. I'm going to just mention what I've mentioned before. If you really want to look through these exhibits yourself, you can go down into the description below, click on the links, download the Petition for Rid of Mandamus, and you can go through these exhibits. If you've been watching the My Docket series in order, you will have already seen all of these filings, and you will have already seen my analysis and discussion on all of these filings. Next, we have a proof of service indicating that the Secretary of State was personally served in Carson City, Nevada. Next, we have another proof of service indicating that my ex was served at her place of residence, the VA hospital. That's not her place of residence, that's where she works. Anyway, that's a typo. At her place of where she works, she was served. We have another proof of service here indicating that my ex's attorney was served. Okay, this is annoying. I think I know why I did this, because there were probably games that were being played between my ex and her lawyer. My ex probably said, hey, my lawyer is representing me. And then I probably said, well, she's not, because this is a new lawsuit. And then her lawyer probably emailed me saying, hey, I'm representing her. Please serve me instead. So I just to avoid this nonsense, I went ahead and served her as well. There may even be an exhibit here. Notice regarding redundant service. Oh yeah, I'm not waiving or stating that this is any kind of acknowledgement that my previous service upon my ex was invalid in any way. I'm just letting my ex and her attorney know that that document is still valid and enforceable. And then here we have, as I mentioned, Exhibit 1, which is an email. Exhibit 1, look at that. I was able to predict what this was. So here's a document for, that's exactly what happened. So I sent an email to my ex's attorney saying, hey, the process server says that Monica's trying to avoid being served. She's hiding, she's ducking and dodging me. Let me know if you're representing her on this case. And then my ex's attorney states, yes, I will accept service for, Monica. So then I went ahead and served the attorney. Proof of service, another one. Okay, so this is proof of service upon the Attorney General. I think this is required by law, guys. When you sue a government entity, I'm pretty sure you have to serve both the entity and the Attorney General. In Nevada, I'm not 100% sure about this, but I'm like 95% sure there are statutes that will dictate this, or maybe it's in the Rules of Civil Procedure. In any event, I have served the Attorney General as well. And then this is just a notice regarding redundant service, just in case the Secretary of State is trying to imply at a later date that my service upon them was not valid or something like that based on my service upon the Attorney General. I don't really need to add this, guys. I don't know why I put it in here. Request for submission. So here I am submitting the petition of writ of mandamus to the court for a determination. I've already talked about this in a filing in the same video, actually. Please watch my video, request for submission. There's a lot behind what this document does. And then a Rule 5 certificate of service indicating that this request for submission has been served upon the Attorney General and my ex. Notice of change of address indicating to the court that I have moved. If you want to learn more about the notice of change of address and why it is such an important document, please watch my video, Notice of Change of Address. This document cannot be overstated, the importance of it. Please watch that video if you haven't seen it yet. It is incredibly important to understand why you have to file this. Rule 5 certificate of service indicating that I am serving this upon both my ex, her attorney, and the government. Order by the court. The court has reviewed my petition for writ of mandamus, and let's see here. He's recognizing that I share joint legal and physical custody with my ex. The court is stating that I originally sought relief by petition for judicial review, which the district court denied. The Supreme Court of Nevada affirmed. Okay, so this is all stuff they've talked about before. Okay, and then here he goes into the publication Falcone v. Secretary of State. He is recognizing that now it is his duty and obligation to exercise his discretion and review these allegations. He's finding it necessary to hold an evidentiary hearing to determine whether or not my ex can establish whether I was actually a perpetrator of DV. And he's basically stating that he's going to comply with the Supreme Court's order or the Supreme Court's publication in this case. Certificate of service under Rule 5 indicating that the judge has mailed this document to me, my ex, and the government's lawyer. And notice here that the judge is still sending this document to my ex personally. He's not sending it to her lawyer because none of these other people are psychic. None of these people know that she has an attorney. For them to know this, she has to file a notice of appearance. Next document here, notice of entry of order. I am indicating that that previous order that was entered was entered. Actually, I shouldn't say that. It makes it seem like this document is silly. This is not a silly document. Please watch my video, Notice of Entry of Order. This is a document that triggers the timelines to file an appeal. I don't want to go into all the technicalities because I already actually covered them in that video. So yeah, guys, if you have a chance and you haven't seen that video, please watch Notice of Entry of Order. And then we got my Rule 5 Certificate of Service indicating that this document has been mailed to my ex's attorney, my ex personally, and the government. Here we have my notice to set, and I am setting an evidentiary hearing consistent with the court's order. If you want to know more about the notice to set and how it works, I have a video dedicated to the topic. Please watch the video, Notice to Set. You can see now why I do all these reference videos. I would end up spending like an extra 30 minutes just going over the same stuff over and over again. Guys, again, do not skip that video. If you're going through the My Docket series, it's a disservice to you to not watch these reference videos because there is so much behind these seemingly innocuous documents. These 1 or 2 page pieces of paper that probably look like they don't matter that much actually matter a whole lot. So please watch the video, Notice to Set. Rule 5 Certificate of Service indicating that I serve this upon my ex's attorney, my ex personally, and the government. And here we have the substitution of counsel filed by the government. Ross Miller, the Secretary of State, through and by his attorney, the Attorney General, Catherine Cortez Masto, is notifying the court that Senior Deputy Attorney General Kevin Benson is taking over this case. This is a Senior Deputy Attorney General, meaning he's a lot more knowledgeable about the law. He is one of the top attorneys used by the Attorney General. They don't want to have one of their lower level attorneys on a case like this. They feel it is important enough that they are upgrading the attorney that I'm going to be going up against here. And we have here a certificate of service indicating that this document has been served upon me. For whatever reason, they didn't serve my ex, but it might be because she hasn't made an appearance or filed a responsive paper in this case. And then here we have the affirmation, which is indicating to the clerk of the court that this document does not contain a social security number. Going into the aftermath, I have filed, oh my goodness, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 documents. The court has filed 2 documents and the government has filed 1 document. All of these documents that I have filed, well, not all of them, most of them are free filings. One of them I was supposed to pay for, but I got forma pauperis status, so it became a free filing. So because of my forma pauperis status, I have incurred $0 in costs. My ex's attorney, my ex, she hasn't filed anything yet, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney hasn't filed anything yet, but she would have began to review these documents based on the email she sent me. She's interested in representing my ex. So let's see here. To review these documents, the application, I don't think she would concern herself with my application to proceed in forma pauperis or the request for submission. I don't know. I guess she might have reviewed it to see if I was like a liar or something, but I just have a suspicion that she just doesn't care. So I guess let's be reasonable. I'll put 5 minutes into that document. So 5 minutes there. 1 minute for the request for submission, which has us at 6 minutes. 1 minute for the court's order, which has us at 7 minutes. We've got 4 proofs of service. I'm going to put those at 1 minute each. So that's 8, 9, 10, 11 minutes so far. Request for submission, 1 more minute, 12 minutes. So we got notice of change of address. I'll put 5 minutes into that so she can update her records. So we're at 17 minutes. The order by the court allowing the case to proceed. I'm going to give her 5 minutes on that one because it's a court order. I lost track of where I was. So we had, let's see here, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 21 minutes so far. We have another notice. So that's going to be, I think, just 1 more minute. So 22 minutes. And then the notice to set. So that's, I don't even think she's involved in that one. just in case she is, we'll put another 5 minutes into that. So we're at 27 minutes so far. And then the substitution of counsel from the government, I'm going to say, let's round that up 3 more minutes. So we're at 30 minutes for all of those papers, which leaves us with the petition itself. That is a document that I think the attorney would have read more carefully. Still, she hasn't had to file anything yet, so I'm going to go ahead and just put that one in at 30 minutes, which is going to take her attorney fees up to an hour. So an hour at the rate of $250 an hour for my ex is going to come to $250 in attorney fees for my ex. The government, I think the government is, they've only filed 1 document so far, which is a free filing, and that's going to bring their cost to $0. I feel like they're going to do the exact same review of all of those documents as my ex's attorney. I think a lot more time is going to go into the government filing their response to my petition, not so much just reviewing my petition. So I think at this point in time, 1 hour for the government to go through all of those papers is reasonable. At the rate of $250 an hour, that's going to come to $250 in attorney fees for the government. As with my previous videos, if any of you guys have any questions, feel free to post them down in the comments below, and I will see you guys next time.